Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in to the October 21 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On May 2nd, the court decided Shurtleff versus the City of Boston. Joining SCOTUScast once more, this time for post-decision analysis, is Professor Scott Gaylord of Elon University School of Law.
On May 2nd, 2022, the Supreme Court of the United States issued its opinion in Shurtleff versus City of Boston, which focused on the government speech doctrine. While the court unanimously ruled against Boston, holding that its refusal to permit a private group to fly a Christian flag on a flagpole outside Boston City Hall violated the group's First Amendment rights, the justices split 6-3 as to the proper way to analyze government speech cases. This disagreement is not altogether surprising, given that the court's prior government speech cases did not establish a clear and uniform test for government speech. Although Pleasant Grove City versus Sumim, the Monument case, and Mattel versus Tam, the case about disparaging trademarks, also were unanimous, Sumim spawned 4 concurrences and Mattel 2. Justice Breyer joined Justice Alito's opinion in full in Mattel, but in Walker versus Texas Division Sons of Confederate Veterans, the specialty license plate case, the court splintered 5-4, with Justice Breyer writing for the majority and Justice Alito writing the dissent. In Shurtleff, things get even murkier. Breyer writes for the majority, and Alito pens a concurrence that criticizes the majority's factorized approach. Justice Thomas, who provided the swing vote supporting Breyer's majority opinion in Walker, now joins Alito's concurrence in Shurtleff, while Chief Justice Roberts joins Breyer's majority opinion, despite having been with Alito in dissent in Walker. Huh? Are you confused yet? Do you feel like you need a flowchart to keep up with the shifting opinions and alliances on the government speech doctrine? How does Shurtleff fit within this framework? Does it harmonize the prior government speech cases? Or does it create new conflicts between and among the justices? And what might Shurtleff portend for government speech cases going forward? In this podcast, we will explore the contours of the government speech doctrine as set out in Shurtleff, discussing the main similarities and differences between the justices and what all of this might mean for the government speech doctrine down the road. Let's start with some general and important points of agreement among the justices. First, none of the justices even hints at overturning any of the court's government speech precedents. Sumim, Walker, and Mattel are preserved, giving practitioners important benchmarks that can be analogized to or distinguished in future government speech cases. Second, all of the justices agree that government speech is critically important. When speaking, the government must be able to discriminate based on content or viewpoint to ensure that its desired message is conveyed. That is, the government must have the right to speak for itself, to say what it wishes, and to select the views that it wants to express. As the court noted in Sumim, quote, "It is not easy to imagine how government could function if it lacked this freedom," end quote. Third, as Mattel emphasized and Shurtleff confirms, the power to discriminate based on content and viewpoint, quote, "is susceptible to dangerous misuse. If private speech could be passed off as government speech by simply affixing a government seal of approval, government could silence or muffle the expression of disfavored viewpoints," end quote. If the government can all too easily adopt private speech as its own, then private expression is threatened, which, in turn, threatens democratic self-government. As Benjamin Franklin put the point in a different context, quote, "Freedom of speech is a principal pillar of a free government. When this support is taken away, the constitution of a free society is dissolved," end quote. Fourth and finally, the justices unanimously hold that the city of Boston did just that, engaged in viewpoint discrimination against private speakers in a public forum, and tried to justify it by invoking the government speech doctrine. Since at least 2005, Boston allowed private groups to raise their own flags on one of 3 flagpoles in City Hall Plaza as part of flag-raising events and gatherings in the plaza. From 2005 to 2017, the city approved hundreds of requests to raise dozens of different flags and never denied a single request. Until this case, when Harold Shurtleff, the director of a group called Camp Constitution, sought permission to fly a Christian flag, which consists of a red cross on a blue field in the upper left corner of an otherwise white flag, as part of the group's observance of Constitution Day on September 17, 2017. Although the city had allowed private groups to raise a variety of foreign national flags as well as flags of organizations celebrating Gay Pride, Juneteenth, Bunker Hill, and even a community bank, Boston denied Shurtleff's request, citing Establishment Clause concerns with having a Christian flag flying on the city-owned flagpoles outside City Hall. The justices agreed that the city had created a forum for private speech and that refusing Camp Constitution's request constituted impermissible viewpoint discrimination. The unanimity of the court, however, does not extend to the proper way to answer the critical question in government speech cases. When is the government actually speaking? As Justice Breyer frames the question in Shurtleff, how should courts go about determining when the government is transmitting its own message and when it is creating a forum for the expression of private speakers' views? For its part, the majority, consisting of Justices Breyer, Roberts, Sotomayor, Kagan, Kavanaugh, and Barrett, adopts what it calls a holistic approach, rejecting a mechanical review in favor of one, quote, driven by a case's context rather than the rote application of rigid factors, end quote. Having decried a specific mechanical application of factors, though, the majority invokes and applies the 3 main factors used in Summum and Walker. 1. The history of the expression at issue. 2. The public's likely perception as to who, the government or a private person, is speaking. And 3. The extent to which the government has actively shaped or controlled the expression at issue. Justice Breyer does not articulate a specific weighting to be given to such factors, suggesting instead that courts must engage in some type of balancing. As he states in the 3rd paragraph of his majority opinion, quote, "We conclude that, on balance, Boston did not make the raising and flying of private groups' flags a form of government speech," end quote. Applying this list of factors in Shurtleff, the majority recognizes that the factors pull in different directions. Some suggest government speech, while others indicate private expression, and that the context matters. For example, according to the majority, the relevant history is of flags displayed at the seat of government, not flag flying generally. This history supports Boston, given that government flags tend to reflect their communities and can convey messages about the government through their content, presence, and position. Consider Francis Scott Key's reaction to seeing the American flag in the morning light fluttering in the breeze over Fort McHenry, or the message conveyed by a flag flying at half-staff on a government building. Thus, the 3 government flags that normally flew on the 3 flagpoles outside Boston City Hall generally conveyed the city's message. But that history does not resolve this case, which involves a program permitting private groups to fly their flags, which brings the majority to the second factor, the public's perception of the speech at issue. This factor, Breyer tells us, quote, does not tip the scale, end quote. A passerby viewing the three government flags, the United States, Massachusetts, and Boston City flags, would be apt to view them as conveying a message on Boston's behalf. But the hundreds of non-governmental flags, which were raised for only a short time and only in connection with private events in the plaza, might not. A passerby might see the private flag and the private ceremony devoid of government officials and attribute the message to the private group, not the city of Boston. This factor, therefore, does not move the government speech needle in either direction, leaving the majority to consider the final factor, the level of control Boston exerted over the flag raisings and the extent to which the city shaped the messages the flags conveyed. Breyer takes this to be, quote, the most salient feature of this case, end quote. Yet Boston had no control over the message or the flag raising ceremonies. In addition, Boston claimed that it wanted to accommodate all applicants who desired to hold events at the city's public forums, including City Hall Plaza. Boston's practice was to approve all applications, never denying a request until this case, and never promulgating a written policy about which flags and messages were approved. This lack of control contrasts starkly with Sumim and Walker, where the government exerted direct control over the monuments displayed and the license plates selected. Accordingly, the majority holds that the factors, or at least the control factor, tips in favor of private speech, which means that Boston cannot discriminate based on viewpoint. But that is precisely what the city did, denying Shurtleff's request, quote, solely because the Christian flag he asked to raise promoted a specific religion, end quote. Boston, of course, could change its policies going forward, effectively shutting down the designated flag forum. But its current policy violated the free speech clause of the First Amendment. As noted above, while Justice Alito, joined by Thomas and Gorsuch, agrees that Boston engaged in viewpoint-based discrimination, he rejects the majority's triad of factors, which are relevant only to the extent they shed light on the, quote, ultimate question, whether the government is actually expressing its own views or the real speaker is a private party and the government is surreptitiously engaged in the regulation of private speech, end quote. For the concurrence, the factorized approach finds government speech, quote, when the government exercises a sufficient degree of control over speech that occurs in a setting connected with government speech in the eyes of history and the contemporary public, regardless of whether the government is actually merely facilitating private speech. This approach allows government to exploit public expectations to mask censorship, end quote. Shurtleff evidences the problem. The majority determines that two of the three factors, the history of flag flying at the seat of government and public perception, favor the city, generally, yet takes governmental control to be dispositive, without explaining how the majority conducted the balancing or why control was the key factor in this or any other case. Such balancing approaches are squishy, my term, not Alito's, leaving judges complete discretion to decide which factors apply and how much weight to give each factor. According to Alito, such a factorized analysis, quote, cannot provide a principled way of deciding cases, end quote. In place of indeterminate factors, Alito proposes a different approach. For Alito, government speech occurs if, but only if, a government purposefully expresses a message of its own through persons authorized to speak on its behalf and, in doing so, does not rely on a means that abridges private speech. Stated differently, government speech is the purposeful communication of a governmentally determined message by a person exercising a power to speak for a government. Thus, for these concurring justices, the government can invoke the government speech doctrine if and only if 1. The government can show that the challenged activity constitutes the purposeful communication of a governmentally determined message by a person acting within the scope of a power to speak for the government. And 2, the government can show that it did not rely on a means that abridges the speech of persons acting in a private capacity. Under Alito's approach, Shurtleff is an easy case. The city's program described the flagpoles and plaza as public forums and listed no criteria for use of the flagpoles other than general guidelines applicable to all users. The city never rejected a request. It never indicated an intent to communicate a message through the private flags, never deputized private speakers, and never indicated that it adopted or fostered any of the varied private messages the flags conveyed. Accordingly, the city's flag program created an open forum for private speech that precluded viewpoint discrimination. The city's subsequent 2018 written policy did not convert such private speech into government speech. Rather than identify a governmental message, the written policy merely codified Boston's prior exclusion of various perspectives, allegedly giving the city authority to discriminate against any flag, quote, deemed to be inappropriate or offensive in nature or those supporting discrimination, prejudice, or religious viewpoints, end quote. Boston's policy, therefore, violated both prongs of Alito's proposed test and was unconstitutional. 2 other points are worth noting. First, in footnote 2 of his concurrence, Alito raises an unresolved and possibly important question: whether states have free speech rights against the federal government. While the First Amendment's text may preclude the federal government's having a constitutional right to speak, states may have such a right. According to Alito, quote, if the states had First Amendment rights against the federal government at the time of ratification, it is not obvious why that right would be eliminated by the incorporation of the speech rights of private citizens against the states through the 14th Amendment, end quote. Thus, going forward, watch to see if Florida, or some other state, asserts a free speech defense against a Biden or some other administration policy. Second, in the wake of Shurtleff, whether the government is speaking is apt to be determined through one or more of the following: the triad of factors set forth in Shurtleff, good old-fashioned analogizing to and distinguishing the court's government speech precedents, which now includes Summum, Walker, Mittal, and Shurtleff, among others, and Justice Alito's 2-part test in his concurrence. As a result, the outcome in any new government speech case will depend on the specific facts of the case and the test or tests that a court adopts, leaving plenty of room for 5-4 or even perhaps 6-3 decisions in difficult cases.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.